Petition allowed.
Applies.
Number 27. -7, 3569 of 2025.
IA allowed.
May I please, Lordship? Lordship, I would like to mention item number 7, Lordship. In this case,
Item
what
number
happened-
7.
7, Lordship.
Okay.
We have to take some instruction. Actually, parties are informed to return back the file. So I need some time to take further instructions, Lordship.
On the pair being made by Mr.
D. Kolita, on behalf of Mr. G.P. Bhomik,
D. Kolita, learned counsel for
appellant,
the appellant. Matter stands adjourned to be listed after 2 weeks.
after 2 weeks, Lordship.
Okay.
Publish.
That's it. Effective in 11 Lordship.
Item 11.
Lordship, matter 2 weeks.
After
2 weeks.
2 weeks. On the pair being made by Miss
Okay.
K. Khan, learned counsel for the appellant. No, learned counsel for the applicant, Shruck, the petitioner. You inform the other side. With consent from the other side, press for listing the matter after 2 weeks. Pair allowed.
It pleases your Lordship. Lordship, I need listing of MSc appeal because Lordship, we need a stay immediately.
Take a date from him.
Highly obliged.
So I document on item number 25.
25.
20.
Yes.
Also, it may be some after 3, talk of compromise is going on. Let's see.
Okay. Mr. K.K. Bhatt, learned counsel for the respondent number 2, with consent from the other side, press for listing the matter after 3 weeks. After 3 weeks. As parties are negotiating to settle the matter amicably. They are allowed. Press shall list the matter after 3 weeks.
Okay.
May I please, Your Lordship, I beg to mention item number 9 of today's date. The matter may be adjourned for 1 week.
Item number 9 for 1 week.
Yes, Lordship. Date kindly may be fixed, Your Lordship.
On the pair being made by Miss
D. Chauhan.
D. Sohan, learned counsel for the applicant, stroke appellant. The matter stands adjourned to be listed after 1 week.
Date may be.
Take a date from him. Yes.
May it please your Lordship, I beg to mention for listing of 3 MFA, my lord. This matter has fixed on 2019, 2019. And since then, the matter has not been.
Take a date from him.
Obliged.
Items for admission, item number 1, Margaret Mehta.
May I please, Lordship? But this is a part of the matter, my lord. Earlier, the government was directed to furnish the,
The matter was initiated for processing and endorsing it to the, formally endorsing it to the finance department. In that matter is in the same process now. In certain further clarifications were sought from the director of the education department, will they have furnished. Now, Lordship, it will process and it will end, the secretary, office of the secretary will endorse it to the finance department. That is my delivery instruction as of now.
So when to be listed?
Lordship, list after 3 weeks, Lordship.
After 3 weeks.
Lordship, there is
After 3 weeks. Heard Mr. M.A. Islam, learned counsel for the petitioner, and Mr. P.N. Sharma, learned standing counsel for the respondent in elementary education department. On the request being made by Mr. P.N. Sharma, learned counsel for the standing counsel for the elementary education department, the matter is then adjourned to be listed after 3 weeks. As Mr. Sharma apprises for that, the respondent authorities have already initiated the process.
Okay.
highly obliged.
Item number 5.
Lordship, this matter may be taken up after some time. Mr. AK Focus, is on the way.
Who?
Mr. Lordship, standing counsel AK Focus.
Okay,
So Lordship may take up after some time.
okay,
He's on the way.
okay.
Item number 6. Item number 6.
Mr. Rashid, you were the counsel for item number 6.
Item 6.
Forty-day, my lord. Formally, I am forgotten. Sorry, my lord.
You have received the copy of the additional affidavit?
Sorry, my lord, it is a Farida Begum. Sorry, my, it is wrongly marked. Yes, I received it.
You received.
So may I submit, my lord? May I submit, my lord? The fact is regarding a appointment, my
No,
lord,
no,
of
the other side is absent. Okay. Sutia, please Sutia. Ever inform karo. Wait for some time.
my.
Item 8 for order.
May I please? Item numbers notes. Kindly see the last order, 24/11/2020.
60. SMT 60. After some time.
Item number 10.
May I please, your lordship? IA number 4174 is related to substitution, delay substitution, your lordship. And there are 936 days for delay in substitution.
Yes.
There are 4 numbers of miscases, your IA. in this.
Number?
4174. This relate 936 days.
Yes, sir. Have you received the copy? Yes. Have you received the copy of this IA? Received. Any objection in condoning the delay of 936 days? No.
If it is pending for since 2012, we have added it.
Okay.
There is another thing.
Heard, Mr. Your good name, please?
Lordship,
Your name, please?
as Hussain,
S. Hussain,
Lordship.
learned counsel for the applicant. And Mr.
A Hussain Lordship.
A. Hussain, learned counsel for the respondent, opposite party. This interlocutory application, no, this application under order, under section 5 of the limitation in 1963 is preferred by the applicant for condemnation of delay of 936 days in preferring the substitution petition. The learned counsel for the applicant submits that. What is the ground for delay?
Lordship, they are laymen and they did not communicate with us that the respondent of 5 has died. And during the COVID period, your lordship, she was died and they did not
The
communicate
learned
with us.
counsel for the applicant submits that during the COVID period, the appellant number 5
Lordship,
suffered demise and the same has not been reported to him, for which this application could not be filed in time. And that the delay is not intentional, rather it is circumstantial. and therefore it is contended to allow the same. The learned counsel for the respondent submits that respondent opposite party submits that he has no objection in the event of allowing this application. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanation so forthcoming for the delay of 936 days in preferring this substitution petition, this court is inclined to allow the same. Accordingly, delay of 936 days in preferring substitution petition stands condemned. In terms of this, IA stands disposal.
Thereafter, your lordship, the substitution petition, that is IA number 4176, your lordship. Respondent number
Art. So and so, so and so. This application under order 22 rule 3 of the Code of Civil Procedure is preferred for substitution of the appellant number 5. Ramila, namely Ramila Khatun by her legal heirs. The learned counsel for the applicant submits that appellant Ramila Khatun, appellant number 5, namely Ramila Khatun suffered damage during the COVID period. And thereafter, the said matter was not reported to him, for which the substitution petition could not be filed in time. And when the matter was reported to him, there was already delay of 936 days
lordship.
in preparing the substitution, this present substitution petition, and therefore an application under Section 5 of the Limitation Act has also been filed, and the same has already been allowed by this court. And since appellant number 5 suffered demise, there is a requirement for bringing on record the legal heirs of the appellant number 5. And accordingly, it is contended to allow this application. The learned, any objection? No. Learned counsel for the respondent opposite party submits that he has no objection in the event of allowing this application. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this interlocutory application stands allowed. Who are the legal heirs of appellant number 5?
Legal heirs are, lordship, those are 1, 2, 3, 4, 5.
5.
Page 7, your lordship. Rukia Begum, that is Dr. Gofur Ali, Nurjahan Begum, Rahima Begum, and Nazrul Ali. These 5 are.
Accordingly,
son and-
provided that the legal heirs of appellant number 5, namely 1 Roman 1 Rukia Begum, 1 Roman 2 Gofur Ali, Roman 3 Nurjahan Begum, number 4 Rohima Begum, number 5 Nazrul Ali is substituted in place of appellant number 5 in the RSN number 22 of 2012. In view of the order being passed in the I number so and so, the learned counsel for the applicant, you are for the appellant stroke appellant shall file amended cost title within a period of 1 week from today.
Lordship.
You have to file amended cost title in the RSA.
Yes, I have filed abatement petition also. There is.
No, amended memo of appeal in the RSA
Lordship. I'll file.
within 1 week.
Lordship. After Bihu, I'll file. Lordship.
And now number 3.
Number 3 is Abatement petition, Your Lordship, abatement miscase. I.
Heard Mr. Swenson. This application
There is
under order
delay.
22,
And
Rule 9 of the Code of Civil Procedure is preferred by the applicant for setting aside the abatement in substituting the legal heirs due to date of appellant number 5 on 16/2/2022 in connected RSA number 22 of 2012. The learned counsel for the applicant submits that the appellant number 5 suffered demise on 16/2/2022 and for substitution of legal heirs of the appellant number 5, already one application has been filed and the same has been allowed. And in view of above, there is a requirement for setting aside the abatement due to date of appellant number 5 in the RSA number 22 of 2012. The learned counsel for the respondent opposite party submits that he has no objection in the event of allowing this application. Accordingly, taking note of the submission of learned counsel for both the parties, this interlocutory application stands allowed. The abatement of appellant number 5 on abatement due to date of appellant number 5 on 16/2/2022 stands set aside. Stands set aside. In terms of this, I stands a disposal.
Lordship.
Recessal leaves the RSA after vacation.
Lordship. Deeply obliged.
Item number 12.
May it please your lordship. My lord, in this case, appeal has already been admitted, lordship. I am appearing in this case, lordship. Earlier, Mr. A. Dutta was appearing. I am appearing on behalf of the appellant. And here in this case, lordship, appeal is already admitted and stay was granted subject to deposit of 50% and steps already taken and law LCR has already been received, lordship.
Okay, matter is ready for
Ready
hearing.
for hearing.
Okay. Heard Miss
M. Chaudhary. M. Chaudhary.
M. Chaudhary, learned counsel for the appellant. In both the
Only item number 12, I'm submitting, lordship.
item number 12. Item number 12.
Item number 12, OIC Oriental.
MSc appeal number 175.
Yes, lordship.
And what is this CO?
CO,
Cross objection.
lordship, since I am appearing newly, lordship, I have not received the copy. I think it is not yet admitted, cross objection.
Cross objection.
I could not see the record, lordship.
Already I admitted.
Admitted, lordship. I was not knowing because I have appeared. newly.
Okay. Furnish one copy to her.
Yes, yes, I'll give it. Okay. A date will be fixed for hearing, my lord.
Uh-huh.
It can be on
Heard
17th.
Ms. Chaudhary, learned counsel for the appellant in MSc appeal number 175 of 2018 and Mr. K. Bhattacharya, learned counsel for the respondent.
No,
Respondent. And also heard Mr. Bhattacharya, learned counsel for the cross objector in cross objection number 22 of 2018. 18. You are appearing in this matter today?
Yes, lordship.
And Ms. Chaudhary for the respondent. Ms. Chaudhary submits that she has not been provided with a copy of that cross objection. Mr. Bhattacharya, however, undertakes to furnish a copy of the cross objection to Ms. Chaudhary during the course of the day.
We don't put on the-
Ms. Chaudhary further submits that MSc appeal number 175 of 2018 is ready for hearing and the LCR has also been received, and as such, it is contended that the matter may be listed for hearing. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recessal list both the matters for hearing on a date to be fixed by the registry.
Lordship. Must oblige, lordship.
Item 13 and 14.
May it please your lordship. In this case also, Lordship, I am appointed recently, Lordship.
Hmm.
And so far as IA is concerned, that is delay already condoned, Lordship, but appeal is not yet admitted. I think, no?
Huh?
That
No,
appeal
no,
is-
no, only my lord.
Only delay was condoned, Lordship.
Here was condemned, my lord.
It may,
And, memo of appeal and which was not published to us. Sir.
since Lordship, I am appointed only to 26 January. January 1st of,
No, this has,
Yes,
this
by
matter has not
126.
been admitted till now.
says not yet admitted. Later matter may come up admission column, Lordship.
But let them furnish the copy, my lord. They have not given.
I will furnish because I was not engaged. Recently, I am engaged. I will service, Lordship. I will
Okay,
give the
okay.
copy.
Heard Ms. Sodhore, learned counsel for the appellant, and Mr. Bhattacharya for the respondent. Number one.
Let it clear. Sir.
How many respondents are there?
Lordship.
Hmm?
Three respondents, Lordship.
Mr. Bhattacharya, are you representing all of them?
Yes. No, only one.
Only
One.
one, it's
Only one.
only respond number one.
Only respondent more.
Okay. This appeal is directed against the judgment and awards dated 14/10/2016, passed by the learned member Motor Accident Claim Tribunal. No, by the learned additional district judge number 3 within Bagat FTC Kamrup M Guwahati in MSc case number 1091 of 2011. 2011. It is to be noted here that by in judgment and award dated so and so, the learned tribunal has directed the appellant herein to pay a sum of rupees 3,73,078 rupees, being the compensation with interest at the rate of 9% per annum from the date of filing of the claim petition till payment. Till payment. Where is the judgment and award dated so and so? And also, where is the memo of appeal? And the grounds mentioned therein? Admit. Issue notice to the respondent number 2 and 3. 2 and 3. By state post with AD and also by usual process within a week from today. Registrar shall also call for the record from the learned tribunal, release the matter after 4 weeks.
Lordship is admitted. That's subject to deposit of 54.
No, Lordship, there is no rule that while admitting, now stay, regarding stay, Lordship,
Yes.
there is a petition for stay, Lordship.
Okay.
And,
But-
and Lordship, since Lordship, the policy does not cover the risks of the disease, Lordship, there is a ground. Therefore, Lordship, let the law court record comes, Lordship, then Lordship will decide the issues.
That the category would say is fine.
No,
That it's deposit.
no, Lordship, because there is a violation of,
First, let me submit the copy, my lord. They have not yet submitted. Let me submit that way here talk on that point, my lord.
Okay, in the meantime, record will come.
Lordship.
Okay. Heard Ms. Sodhore, learned counsel for the applicant, Mr. Bhattacharya for the respondent number 1. This interlocutory application is preferred by the applicant for stay from suspension of the judgment and award dated 14/10/2016, passed by the learned additional district judge number 3 FTC, Kamrup M Guwahati in MSc case number 1091 of 2011. Mr. Bhattacharya submits that he has not been furnished with a copy of the interlocutory application. Ms. Sodhore submits that she will furnish the copy of the same to Mr. Bhattacharya during the course of the day. The pair of the applicant will be considered on next date on receipt of the record from the learned
Yes.
tribunal.
Must oblige, Lordship.
15.
I am for the appellant, my lord, in this case, LCR has come. So it may be fixed.
For hearing,
Yes, please.
Fixed for hearing.
Mr.
Yes,
Heard
yes.
Mr. Bhattacharya, learned counsel for the applicant, and Mr. Bhatt for the respondent number
TN2.
3 and 4. 3 and 4. 3 and 4. It is submitted at the bar that the matter is ready for hearing. Accordingly, it is provided that Registrar shall list the matter for hearing. LCR has received.
Yes, my lord. Can the date may be fixed, my lord? It's a matter of 19. 12 February. 12 February. Oh,
Item number 16.
May it please your lordship.
Yes.
IA is for delay of 28 days. And
Delay of?
IA is of delay of 28 days. Service for respondent number 5, we have taken paper publication, but affidavit is not yet filed, lordship. Some time may be granted.
Okay. Ms. Musahari, heard Ms. Musahari, learned counsel for the applicant. Ms. Musahari submits that notice upon respondent number 5 has been, and the service of notice upon respondent number 5 is effected through paper publication, and she may be granted some time to file an affidavit to that in that regard. Pair allowed recessal is a matter after vacation.
Be obliged.
Standing item.
I was starting to check down those things.
So what is the stage now?
It is in the actually is going on at a government level as soon as this is found. We have received a proposal from the director. Now matter is on consideration is going on lawsuit. As soon as after we send to the final event for approval lawsuit. So we need some time lawsuits. That is the instruction that I have received. The government is under process of lawsuits. Yeah, right. I get to know. Get to know. We have received a formal proposal from the director of elementary education.
No, that was the position in the month of November.
Yes, that is.
Now we are in January 2026.
That is what I have wrote to them back. Lawsuits. That is what I have lost back. I'll give you 1 week time. Lawsuits. That is what I have said. Lawsuits. It is a matter of.
Okay, heard
So
Mr. Islam, learned counsel for the
Urgency should be there.
petitioner, and Mr. SMT Sister, learned standing counsel for the learned counsel for the contender. Mr. Sisti submits that he may be granted 1 week time
Yes.
to obtain up-to-date inspection. Yes, the matter has already, and the matter is already under process of the contemners. No, being processed by the contemners. Pair allowed recessal is the matter after a week.
But kindly fix the matter, man.
Take a date from him.
On 26. Sorry, 28.
Obliged.
Item. 17.
My pleasure. It's a review petition. Our petition filed under Article 227 was dismissed, holding that it is not maintainable because appeal lies in a order under Order 9, Rule 13 on dismissal. What happened, Lordship? A suit for specific performance was filed against me. Thereafter, it was proceeded ex parte for some reason. We filed an application for that vacating the ex parte order and give us opportunity to file written statement. But wrongly, in the cost title, provision was quoted as Order 9, Rule 13. Order 9, Rule 13 is for setting aside ex parte decree. There was no decree was passed. It was proceeded ex parte. We filed an application for vacating the ex parte order and giving us opportunity to file written statement.
Mr. Ghosh, are you ready to argue the matter?
My lord, it is a review application, my lord. There is no error apparent on the face of the report because your lordship says after considering the Supreme Court judgment, passed an order that it is an applicable order and alternative remedy under Article 227 cannot be resorted. So it is correctly passed by this honorable court that the.
No, that's all right. But are you ready to argue the matter today?
One may, I can, my lord, because.
You can. You are ready.
Yes.
You are also ready.
I'm also ready, but in any case, Lordship, it may come after vacation.
After vacation?
Review vacation. It will be
Okay.
better. Review vacation.
Okay.
A date may be fixed already. No?
Okay. As agreed by learned advocates of both the parties, the recession lays the matter on
February.
5th of February.
Obliged.
On that day, endeavor will be made to finally hear and discuss.
Yes,
the
yes,
matter.
Lordship.
Please, your lordship. This is a application for withdrawal of the statutory deposit, which was deposited at the time of filing appeal. Case was settled between the parties on 11/5/2024 before the National Lok Adalat.
Heard, Mr.
S. Sharma.
Learned counsel for the applicant. This application, interlocutor application is preferred by the applicant for allowing to withdraw the statutory amount of rupees 25,000 deposited before the registry of this court, while preferring the appeal against the judgment and award dated 30/3/2017 passed by the learned member, Motor Accident Claim Tribunal number 1, Kamrup M. Guwahati, in MSC case number 2548 of 2014. The learned counsel for the applicant submits that the matter has been settled in the Lok Adalat during the National Lok Adalat held on
11/5/2024.
11/5/2024, but no order was passed regarding withdrawal of the statutory deposit, and as such, this interlocutory application is filed for allowing to withdraw the allowing the amount of rupees 25,000 being deposited before the registry of this court. In view of the submission of learned counsel for the applicant, and also considering the fact that the matter has already been settled between the parties, this interlocutory application stands allowed, allowing the applicant to withdraw rupees 25,000 from the registry of this court. In terms of this, IA stands closed.
Item 19.
Your Lordship, this is an application of continuation of delay of 50 days, Your Lordship.
Heard, Miss?
K. Sharma.
Learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred for continuation of delay of 50 days.
50.
In preferring connected review petition of the expertise judgment and order dated 28/6/2025 in CRP IO number 209 of 2025. Where is the order?
Your Lordship, the order has not been attached.
Is it the procedure? Hmm?
Yes, Your Lordship.
On perusal of the application, it appears that the order dated 28/6/2025 passed in CRP IO number 209 of 2025 is not enclosed with the application. Accordingly, it is provided that the applicant shall file one additional affidavit bringing on record the order dated 28/6/2025 passed in CRPIO number 209 of 2025. List after the vacation.
Second 20.
May I please your lordship? Lordship, this is an application section 151 CPC. Your lordship, annexer to page number 15 and 16 is wrongly annexed, lordship.
Annexer?
Annexer to page number 15 and 16. Is a order is wrongly annexed, your lordship.
Pardon, miss? Your name?
Miss S. Das on behalf of R. Goswami.
Miss S. Das, Learned Counsel, appearing on behalf of Mr. Argusami.
Ah,
Learned Counsel for the applicant and Mr. Proceed for
Applicant.
appellant. This application under section 151 and order 39 rule 4 of the Code of Civil Procedure is preferred by the applicant for granting injunction and for alteration stroke modification of the order dated 23rd/5/2018 in IA Civil number 1675 of 2018. The Learned Counsel for the applicant submits that annexer number
2.
Annexer number 2 and the annexer number 2 has wrongly been enclosed with this application. And as such, he prays for granting her some time to bring on record the exact order being passed by this court by filing an additional affidavit. They are allowed to recess the matter after vacation.
Date 27
Much obliged.
Granting items 2 to 5. After meeting.
In this matter, Kaushik is hearing. He is due to personal difficulty, he is unavailable now, So I have requested the council also, can this matter be fixed on 22nd or 27th, any of the day?
This is a part.
Because it's a part-time matter. It will be
Yeah, part of matter, Lordship, I have already argued in some length. In fact, today I'm also prepared with a brief note which I have already been in place before this court. I can giving in to Lordship, and matter related to retirement benefit. A teacher after working more than 30 years of service.
No, that's all right, Mr. Borua. If the other side is not ready for hearing today, what to do?
Then Lordship will immediately after vacation on 21st. Because I'm a petitioner.
No, maybe for next week, this court is not sitting here.
Yeah.
So we will release the matter from Parthad.
No, Lordship also audio hard. I'm not on that. Lordship.
No, as because for coming 2 week, this court is not sitting here. Why should I keep the matter as Parthad?
Lordship already I will oblige Lordship will take it in Parthad. In Lordship convenient fix the date.
Yes.
I leave it to your lordship, but my lord will kindly have it after the big vacation because the council.
Heard Mr. Borua, Learned Counsel for the petitioner, and Mr. Fukun, Learned Standing Counsel, appearing on behalf of Mr. Kosik, B. Kosik, Learned Standing Counsel for the respondent in Elementary Education Department, Ms. Fukun for respondent number 8. Respondent number 8, and you for? What is your name? KK Mehdi. Learned Counsel appearing on behalf of Mr. SK Mehdi. Learned CGC. Is it not CGC? CDC as well as can be cancelled from the company. In this case, learned standing counsel for the accountant general. Mr. Phukan submits that Mr. Kaushik will argue this matter and he is not present in the court due to some personal difficulties. And as such, he prays for listing the matter after the vacation. Accordingly, it is provided that rest shall list the matter after vacation as parted. Dated 22.
Number 21.
My lord, in this case, there are four applications, my lord. The sole appellant died. And there is a delay in setting aside abatement and also there is a delay in filing the setting aside abatement.
Mr. Ghosh, you are appearing in this matter? You have no objection. You are appearing for respondent number opposite.
Sole
party.
respondent, my lord, sole respondent.
Sole respondent. Okay.
Only one, another I have filed for injunction.
Today.
No, it was filed earlier.
Earlier filed.
But will I hear the matter after this application?
They come, yes, my lord, only.
Filed injunction against the legal year. During pendency of this appeal, it was abated. They have started construction. Immediately, I filed application under 151 CPC. That either it may be abated or injunction may be granted. Then they have filed this application for substitution.
My lord, only after filing of his application, we came to know that the appellant died. And my lord,
He is appearing for appellant and appellant.
we have no idea, my lord. He is the sole appellant. He is survived by wife and two daughters. They have no idea what to do. Therefore, my lord, only after somehow we contacted the local council of Silchar, we informed him, then only we knew that there is a appeal is pending. And he is suffering from cancer from 2023. Ultimately died on 24/10/24, my lord. That is why. And he could not have filed that application which he has said, file, my lord. Since there is no one on record, how come he filed an application? They are not substituted, they are not brought on record.
No, therefore,
Yes.
my contention is that after this application being disposed of,
Yes.
only thereafter we can consider your application.
Yes, that is why I am saying that let the substitution be allowed. I have no objection.
Heard Mr. Chakraborty, learned counsel for the applicant, and Mr. Ghosh, learned counsel for the opposite party. This interlocutory application under section 5 is prepared by the applicant for condonation of delay of 219 days in preparing the application for setting aside abatement. Mr. Chakraborty, learned counsel for the applicant, submits that
Grounds are stated at paragraph 3 and 4. Basically, you are suffering from cancer. And ultimately,
that Partip Chakraborty.
yes, ma'am.
Partip Chakraborty, the appellant in RFN number 123 of 2019, suffered demise on
20/10/2024. 20 October, my lord, 2010.
20/10/2024. 2024. Leaving behind three legal heirs, namely Aruti Chakraborty,
Priya Chakraborty,
Miss Priya Chakraborty, and Miss Priya Chakraborty. Both are Priya Chakraborty.
No, my lord, actually it has to be and Pooja Chakraborty, yes, my lord. By
Pooja
mistake.
Chakraborty.
Yes, yes,
Okay.
I'm sorry, my lord.
Pooja Chakraborty and Priya Chakraborty. And the aforementioned legal heirs are required to be bring on record by filing substitution petition, but in preparing the substitution petition, there is delay of 219 days. And the cause of delay has been explained in paragraph number
3 and 4, my lord.
Paragraph number 3 and 4. What is the ground?
Ground, my lord, basically he was suffering from cancer and he was undergoing treatment both at Madras and ultimately Kolkata. Then
And-
he was shifted to Silchar where he died, where undergoing
that-
treatment.
Pradeep Chakraborty, the appellant in RFA number 123 of 2019 was suffering from cancer. Then he
Throat
was
cancer.
undergoing treatment at Madras and Calcutta. And ultimately, he suffered demise on 28/10/2024. And as such, there is a requirement for bringing on record the legal heirs of late Pradeep Chakraborty. And the delay in preferring the application is not intentional, rather it is circumstantial, and under such circumstances, he is contented to allow this application. Mr. Ghosh, learned counsel for the opposite party submits that he has no objection. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the explanations for forthcoming for the delay of 219 days, this court is inclined to allow this application. The delay of 219 days in preparing the substitution petition and setting aside abatement stands allowed.
Substitution is 23788.
Okay, we will pass an order.
Yes.
There are four
Four, my lord, four. Yes, four application. See, the ground is same.
Okay. In view of the order passed in the IA, Mr. Chakraborty, learned counsel for the
Applicants.
applicant's appellant
Yes.
in RFA number 123 of 2019 shall file amended cause title within immediately after
After
the
due
opening of the
vacation.
vacation. This so to fix a date.
My injunction 2705. I 2705.
Let him file the amended
Yes.
cause title. Therefore, we'll hear on next that the application, interlocutory application number 2705 of 2025 will be considered.
Obliged.
Because they have started construction.
No, my lord, we have not.
Let if that submission is recorded.
No, on that day. we will
Yes,
hear.
my lord, yes.
On 5th February.
Deeply obliged.
Timing item 6.
Madam, this is regarding appointment of Anganwadi helper, my lord. And kindly see the annexure 1, my lord, that is, my lord, advertisement, page 15. A post was lying vacant, my lord, then my lord, advertisement made, my lord.
Mr. Sutia, you are appearing for the department.
Seva, my lord, Seva.
Seba.
That Seva, well, I have made him party, my lord, only for that, because there is a condition there, the running regular student, he cannot apply. But the head principal issued a certificate in between a course, my lord, and that is to get clarification whether that headmaster or principal has the authority to issue such certificate or not. Only that point, my lord. So, my lord, without making him party, my lord, he will not come. Only that simple point, my lord. And running student, my lord, cannot apply.
No,
but
who is appearing for
here
the
is-
department?
My lord,
Who is appearing for the department?
department, my lord, the government was appearing, my lord, but I don't know.
But I will appear.
You will.
For the government, Ballot. Both Mr. Roy will appear for both.
Oh, it is.
Social Welfare Department.
Yes, Mr. Now, my lord, that one condition is there, my lord, a regular student cannot apply. I am coming only to that point, my lord, here, my lord.
So one
Please.
additional affidavit was filed, Mr.
Right.
Sutia, are
have
you
found.
aware of the same?
No, my lord, yes,
You have seen.
Page 17, last sentence, my lord, your lordship may kindly see. The regular student of a school college cannot apply. Page 17, paragraph 12, my lord, the last date of so, my lord. The candidates will be cancelled on the following grounds. 1, 2, 3, 4, etc. my lord. Only formula I given, regular student of a school college cannot apply. So, my one,
Paragraph number 7.
paragraph number, my lord, I have given 17, page
The page
17,
17, paragraph number
paragraph number 12, paragraph 4,
12 for regular student of the
school college cannot
regular
apply.
student of college, school and college.
Above written cancellation, the candidates will be cancelled on the following grounds. And I have shown, trying to show me that the respondent number here, respondent who is selected me and appointed, he is a regular student of his school. We are higher secondary school. I have given certificate and kindly similar that schools-
Whether regular student of school and college can apply?
no. That is the answer, yes. And school certificate, Milan, I have annexed here, Milan, you will also may kindly see.
1, 2, 3, 4, 5.
Page 34, Milan, yes.
On Friday, but he is waiting for the principal. But he can say whether it's a regular student or not.
It is in the record, Lordship. ICDS officer wrote a letter, whether he is student or not. I accept that. Informed by a letter which will link to the requisition of Lordship. I have no Lordship. Since I have been big party, I am maintaining Lordship.
But the principal, Milan, issued a certificate.
Some information something has been replied, and it's the part of the annex Lordship. Case 32. Once he was a student, due to financial crisis, he took on.
That on that ground, student cannot leave. Nowadays, Milan, that student cannot leave school on a halfway, Milan. And kindly see page 32, there is not, he has,
Notice may issue a distance banana. I will obtain instruction ballot and it will also try.
Notice was not issued earlier.
not issue, Milan, yes. There is notice issue, Milan, yes. Yes. It was notice issued, Milan, and Milan, I have taken steps, all have been repaired, Milan, and service is completed, Milan, on 25/6/25, Milan, service is completed.
Okay, Mr. Sutia, if you are not ready today, let it be on Friday.
Friday.
Huh?
I will go through it.
Okay. Heard Mr. Rosin, learned counsel for the petitioner. Mr. Sutia for the respondent number
1 to 5 ballot.
1, 2, 5, and Mr. S.U. Ahmed for respondent number 10. Mr. Roy for
Respondent number 9.
respondent number 9. Respondent number 9. On the request being made by Mr. Sutia, learned standing counsel for the respondent number 1 to 5, the matter stands adjourned to be listed on Friday.
Okay. As Milan, Partha is there, Milan.
Partha.
Yes.
Item for hearing. Number 22 and 23.
Please, your lordship. Lordship, senior counsel Mr. Z. Kamar is on legs, lordship, in another court. After at 2, lordship.
Correct. Okay, let him come at 12 o'clock.
12, lordship.
Yes.
Lordship.
Item 24.
My lord, senior counsel is busy in civil court, my lord. Kindly, after 2, my lord. For the time being, Mr. Upadhyay, my lord. I am on behalf of.
After
2 p.m., my lord. Today
we don't
itself.
have a matter
Today,
to
my
be
lord.
taken up in the second half.
The second half, my lord.
Our list over.
Oh. 12 put খুলে থাকতো।
For time being, let him come.
Time being, time.
Not at two.
My lord.
Here in this case, though, we have raised the question of the materiality of this revision, instant revision. But here what happened, the petition of this IA, as a plaintiff filed the suit for partition and declaration of right title interest. And here my lord, one Sasi Kolita, alias Kasi Kolita, was the absolute owner of the land. And she is my mother. She had 4 daughters, 5 daughters, and 1 son. Son died.
No, this IA is for what purpose?
For the raising the question of materiality of this revision.
Pardon?
Materiality. Revision petition of the revision petition, materiality. They have filed the revision petition challenging the judgment on admission. So we said that since the order is the judgment on admission, the appeal lies against that, not the revision. That is our contention. Lordship will straightway see the which order was passed on judgment on admission. That is page number 119. The whether question is very simple, Your Honor, Lordship. Whether the appeal lies or their revision lies. That 119, last page.
Correct. There look at that matter.
Revision. This is the order passed on judgment on admission. Lordship, I read the judgment. This is the order. Order is dated 15/12/2022. The party are represented, learned counsel for the opposite party of the defendant has filed a written objection. Heard both the side on petition number 2271/2021 order under order 12 rule 6 CPC filed by the petitioner plaintiff praying for the judgment and the decree on admission. Also perish the written objection filed against the petition. The plaintiff had filed the main suit for declaration, confirmation of possession and partition and permanent injunction. A meaningful reading of the rival pleading of the parties disclose it is an admitted position that late Sasi Kolita, alias Kasi Kolita, was the owner of the suit property and the party to the suit, admittedly the legal years of the deceased owner. It is also not in dispute that the suit property is yet to be divided among the parties. Further, defendant one has also admitted that she has been collecting the rent from the tenant of the suit land. During the hearing, learned counsel for the opposite party submitted that the OP has no objection against the relief claimed by the petitioner for the partition of the suit property, in much as the relationship between the parties and the nature of the suit property are not in dispute. Learned counsel for the petition submitted that if the OP agree to partition the suit property and the party get their entitled.
So in
Entitled
fact,
share.
this order is a consent order.
My lord.
So My lord, in this method, in that step, one second paragraph, 119, my lord, second, third paragraph, London Council for the office submitted, the office has no objection. Then my lord, I have argued the case on that date, so I raised objection. Subsequently, when the order was, my lord, read out, my lord, thereafter I go to the my lord, court chamber, my lord, that I submitted before the court. That was my not submission. I have never given no objection. At least court may pass any order. But if the same submission is quoted, then there is a repercussion or allegation from my client. That was my not said, was not my not submission. On that day itself, thereafter the court already has had the order. It was not my submission at that time. Otherwise, I have filed objection. I have filed objection, written objection, this petition, and here I am orally given no objection. Whereas I have submitted written objection before the learned trial court. On that day itself, my lord, I entered it along with my associate members.
But whether you have filed any application before the trial court?
I have subsequently, I have not submitted. Thereafter, I have filed this revision petition, my lord.
No, no, on that day. Whether you have filed any application before the trial court that you have not submitted in
Made
the
any-
manner. It is reflected in the order dated 15/12/2022.
No, that was not submitted.
Then why should I believe you?
My lord. Okay, but I have filed my written objection
Maybe.
in the case, my lord. And then thereafter, my lord, that was not in the package shoot, my lord. That page was 1117.
Now the question is whether appeal or revision will lie against this order.
Appeal lies.
But at my lord, it is a revision rights because as per section, my lord, section 96(3), CPC no appeal shall lie from a decree passed by the court with the consent of the parties. When the petition order was passed in the order.
So this is this order is a final order. 15/12/2022.
That is the misstatement, but in the package shoot, my lord, that was not final. Sir. Before getting the judgment, I filed this revision, page 1117. In view of the order passed by in Mijay case.
No, this is common order in the Mijay case and also in the title suit.
My lord,
Hmm?
the initial suit is posted for hearing judgment on 4/1/23, my lord. Page 117, my revision petition.
This against the judgment on admission, whether appeal or revision will lie.
My lord, revision will lie.
How? Under which provision?
My lord, section 96(3). 3.
Hmm. Yes, Mr. Upadhyay, what is
My
your
lord,
submission
yeah.
on this point? 96(3).
A learned friend pointed out that or section 96(3), no appeal shall lie from a decree passed by the court with the consent of the party. It is a compromise. I think it is in regard to the compromise decree. It is not a compromise decree. It is a judgment on admission. Judgment on admission, your lordship will see the section state that the very elaborate section, the where the judgment on admission, where the admission of the fact has been made either in
You
the
are referring to which provision?
order 12, rule
Order
6,
12.
CPC,
Yes,
CPC,
order 12.
order 12, rule 6. I read, judgment on admission, where the admission of the fact has been made either in the pleading or otherwise, whether orally or in writing. The court may any stage of the suit either on the application of the party or it on motion, and without waiting for the determination of any other question between the parties, made such an order or give such a judgment as it may think fit, having regard to such admission. Whenever a judgment is pronounced under sub rule 1, a decree shall be drawn up in accordance with the judgment, and the decision shall bear the date and on which the judgment was pronounced. So then here it appears from the order dated 15/12/2022 that they during the hearing, it is noted here, during the hearing, the learned counsel of opposite party submitted that the OP has no objection against any relief claimed by the parties for the partition of the suit property, in much as the relationship between the parties and the nature of the suit property are not in a dispute. So no objection was expressed. No objection, verbally no objection was given by the defendant side. Otherwise also suppose no objection was not given. No objection was not given. Even then,
Mr. Upadhyay, you say the language used in subsection 3 to section 96 is with the consent of the parties. And in
the consent of the party.
Rule 6 of Order 12,
Yes. 96.
it is admission.
No appeal shall lie except on the position of the law. No appeal shall lie from a decree passed by the court with the consent of the party. But the judgment on admission and the consent of the party is a different thing. Here,
How?
here, lordship will see they have made the admission for the partition in the pleading itself. Admission, there must be admission, even oral submission, oral consent is also sufficient for passing the decree. But I think that in the pleading also, court cannot ignore the pleading. In the pleading also they have admitted. In the pleading, in the written statement, they say that so far partition is concerned, they have no objection. They admitted.
Let us see the relevant portion of the written statement.
Let us see.
Page number.
Page number 32, start from the written statement.
Page number 30.
32. From,
30.
It start from 32. Relevant para 10.
Where it is, where they have admitted?
Para 10 and
Para 10.
particularly not particularly admitted, they have the para 15. Para 10, your lordship will see para 10. The statement made in para of the petition are not wholly correct. So the answering defendant denied the same. It is admitted to the extent that Shashi Kolita and Kashi Kolita died on 12/3/10, and upon her death, the suit lane devolved upon the legal heir, that is plaintiff and the Gauri Kolita. Gauri Shankar Kolita, and the Gauri Shankar Kolita married defendant number 1, Srimati Robita Barman Kolita on 2/5/12, and out of their wordlek a child was born, namely Daniel Kashyap in the year 2012, but unfortunately Gauri Shankar Kolita expired one, and upon the death her undivided share devolved equally. Your lordship will see. I can read. Devolved equally upon his wife defendant and his minor son. As a matter of fact, equally. Devolved equally. Now, your lordship, what we have pleaded. Now, your lordship will see what we have said. The plaintiff, our case, lordship will see our pleading, what we have stated, what they have admitted. In first, your lordship will see the written statement, para 15. The statement made in para 9 of the plaintiff are being matter of law are admitted by the answering defendant. 15, lordship will see. Para 15 of the written statement.
So now the issue is whether judgment on admission and consent decree are same thing or not.
Now, consent decree is a different thing. The consent decree and the judgment on admission is quite two different things. Judgment, in a judgment on admission, the party should, the defendant should admit the case of the plaintiff. Should admit the relief claim by the plaintiff. Here the relief claim by the, in the instant case, relief claim by the plaintiff has been admitted by the defendant. Your lordship will see the para 15, para 15 of the written statement. The statement made in para 9 of the plaintiff are being matter of law are admitted by the answering defendant. Now, what is the in 9? 9 of the plaintiff. And
where is the plaintiff?
Plaintiff start from 20. Page number 20. Start from page number 20. And what is in our case is, lordship will see. Para 15, your lordship will see. Or para 9.
Page 25.
25, na?
Yes.
25.
Only this, but the plaintiff identified 160.
That admitted.
Of the two land and the.
In the written statement at paragraph number 15, this has been admitted. Then thereafter the court has passed the judgment on admission. Now the question is, judgment on admission and decree, consent decree are same thing or not?
The
consent decree
ultimately judgment on admission by the consent. This my reading.
No.
It is a matter of law. If whether I can deny matter. As per Hindu once it shared, will get everyone. It a matter of law, a matter of statutory provision. How can I deny my lord? That is why the statement that 9 billion and being matter of law are admitted by the answering defendant.
No,
Matter of
that's all
law
right.
by-
On that ground, the court has passed the decree, passed the order.
But on that ground, only that much matter. Upon this like matter in paragraph, the court passed the order.
Yes.
Whether my lord, in the footland, my lord, whether I entitled or they entitled or others.
No, that is not the issue before this court. The issue before this court is whether this revision petition is maintainable or not.
Yes, my lord. That is a bit not. My lord, for a few minutes, that through the, my lord, order 43, my lord. My lord, appeal from orders. Order 43, CPC, my lord.
Order 43.
My lord.
Order 43 rule.
My lord, all rules, my lord, all rules one. Appeal from orders. From which orders appeal lies matter. There, my lord, nowhere is all the rules, nowhere is written that order 12, rule 6 is applicable. CPC order 43. Order are applicable, that's it, my lord.
Now, order 43 is not applicable in the instant case. Order 43 is not applicable. Appeal from the order.
Yes.
But appeal from the judgment, appeal from the decree. Forty-three is not applicable.
And another case law, last occasion I had submitted before your lordship. The last occasion, my lord, I had submitted before your lordship that is most probably in the estimate of I am submitting this another one. I have only one probability. There are 11. There are 11.
Yes, it is. Yes. Sir.
Judgment on admission is a final, and no, there is no option for appeal. There is no option for appeal. There is no option for appeal revision. No option. Permanently admission will be applicable.
Revision like আসে নাকি তারপর?
No, এটা খুব জবাব কিছু তাতে আছে। এটা আছে দিয়ে দিব। নাই।
No, that is all right. Here, no proposition of law is laid down in respect of maintainability of the revision or appeal. But
The
so this is the only point to be decided by this court. Okay. We'll decide.
Lordship will say.
We'll pass the order.
Our application from our application. Judgment on admission, that is page number 90.
Page number 19.
Lordship will 97.
No, you have filed an application before the trial court.
Yes, that application your
No,
lordship
not
will find
necessary.
at Page number 97.
Okay, we will pass the order.
Yes.
Yes, next item.
There is some judgment if I will apply.
No, some of the judgments are already there on the record. Okay, you may submit it, but furnish a copy to Mr. Upadhyay also.
May I please?
So, Mr. Borthakur, this GR record 903 of 2016 has been received by this court.
Yes, well, both is available, but I have also flagged my vital portions of the
Okay.
636.
Okay.
Your Lordship,
Mr. Kamar, you might have completed your argument.
Factually, I have done, my lord, only the legal aspects I have to address, my lord.
Okay.
That much so, my lord.
Okay.
So I'll not take much of a time. I'll not
Okay.
take much of a time, my lord. but-
Okay, okay.
Yes. So facts, your Lordship has got it,
Mm.
but just giving an appraisal, my lord.
Mm.
There are three things before your Lordship.
Mm.
One is regarding quashing of a complaint filed against me.
Mm.
Number two, kwan hai? File में work किया, file ऐसे ना करते हैं। फिर नहीं।
Division
कौन ना दूसरा case number?
107 of 2018.
ये तो की है?
Our FIR was submitted to HMD.
My lord, there were two things, my lord. One is criminal petition 74 of 21.
Mm.
No problem. Hmm. My lord, I have already given the list of days and everything, my lord. Just
List
pointing
of
it out.
dates.
Oh, yes, my lord. No, earlier, my lord. It's in the record probably. If not, then I'll give it again, my lord.
Yes, madam. That's there in the record, madam.
Yes, yes, it is there.
My lord, I'm saying so that in criminal petition number 74 of 21, I am an accused, my lord.
Mm.
And on 2/4/2016, an FIR was filed by person of Jorhat, my lord.
Mm.
And that case was registered as Jorhat PS case number 636. I have come for quashing of that in view of further developments which I already stated, my lord.
Mm.
And there is another criminal petition, my lord, 107 of 2018, my lord, wherein I have made those person as an accused in this case, my lord. And my case was ended in FF. The final form was given, final report is given. I showed the defect last time, my lord, that I was showed that I'm the informant of that case. I was showed that I was called examined, which is completely wrong. The police in a routine manner to support that case, my lord, they have filed a wrong and false final report. Because my contention is that I was also given a certificate from the JB college that I have passed BA. At the same time, they are also producing a document to show that the pass certificate and the mark sheet that was given were not genuine, where I am the accused, my lord. So now the facts remain, my lord. For that, I have also filed a civil title suit, my lord. After one round of legal battle from the Honorable High Court, we have filed a
suit also.
Hmm.
That suit is still pending because that has to be pronounced that which one is the correct document now
Hmm.
and on what basis.
Hmm.
So this is the backdrop before your lordship. And in my case, my contention, wherein the final report is given, my lord, my contention was that in a routine manner, the final report has been submitted without examining me. When the record was called for case diary, your lordship, it can be seen that my statement was recorded. But I was never issued any notice and no documents was taken from me. And one vital aspect, that document, JB College certificate, no person has been examined from the JB College to say that he. So my respectful submission so far that criminal petition number 107 is concerned, my lord, that needs further investigation. And I have given a judgment also from the Supreme Court when both civil and criminal cases pending on the same matter, then civil court finding will prevail, my lord. That is already before your lordship, my lord. So now your lordship will come back to the today's issue, my lord, the legal aspects, my lord.
Where are we about? Judgment is level of the same, judgment.
In the case that it shows that my statement was recorded, but my specific plea before the trial court itself was that I was never examined. The IO himself has wrote all these things.
Pradeep Kumar. Isa Manjula.
No,
My lord. Mr. Kamar, this is a new list. Earlier list only you have cited 5 decision. Change. 4 decision.
my lord.
The
These
representation of
these
people act also.
These are the earliest, my lord, regarding civil law and all these things. Now I am coming because your lordship has put certain query on the last occasions, my lord. Because this is the third day probably we are arguing before your lordship, my lord. On the second day, your lordship raises certain legal queries, my lord, which I would like to answer vis-a-vis my case also, my lord. Others list of dates is there, I believe. Then sir. Then I got list of dates and everything are there. In both the cases. No. Sorry. Hey, judgment keta ulai diyo apna. Today's right? Yes, today we have given the citation.
Okay.
We have quoted the relevant paras, my lord. Shall I start, my lord?
Yes.
My lord, in this first judgment, that is Pradeep Kumar Keshwani versus State of UP 25 Live Law SC 880, my lord. The Honorable Supreme Court in this case, my lord, at para 20, my lord, emphasizes that following 4 steps. Earlier, Bhajanlal, it was 7 criteria, my lord. Now, in this judgment, my lord, 4 further steps has been given, wherein the accused can seek the quashing of a criminal proceeding initiated under 482. Para 20 says the following steps should ordinarily determine the veracity of prayer for quashing raised by an accused by invoking the power vested in the High Court under 482.
But where is the judgment?
Oh, my lord, sorry. My lord, we have given the list. It would give this. Even all photos that could be. Also list of books. Already, probably, I mean, the last paper received. Oh, like. Ticket of photos. पता है भाई it was not it out did you it photos से बता no photos state करो এই download ना बने
So you do not have the additional copy?
My lord, actually, probably we took 2 copies for your lordship. I don't remember exactly whether on the last date we have given it or not.
No,
Because
no.
on the last date, there was no hearing,
No,
my lord.
this list is furnished
No, no,
today.
this,
So where is the question of furnishing
no, no,
the
no, no, my
citation
lord.
earlier?
This list, earlier, my lord, that election plea was also taken. That I have deleted it from that earlier list, my lord. So what we now say is that we have condensed it, my lord, today. Earlier, there was, your lordship will see that one election point was also taken, but I realized subsequently that that was taken not correctly, my lord. I regret for that. After reading whole during the holidays, my lord, I could come to note that that was relating to filing of nomination, my lord. Here, there was no nomination file, my lord. Here, it was an RTI file, my lord. So I have to recast the list, my lord. So we'll give it, my lord, today. If your lordship want, we'll give it, my lord. We'll submit the documents, my lord.
But copy of the same has to be furnished to Mr. Borthakur also.
Oh, I'll give it. That also I'll do it.
Then can you furnish today, right now?
No, right now too, I'm handicapped, my lord, but.
Right now you are handicapped. Let it be tomorrow then.
My lord, tomorrow, my lord, I have some difficulty.
What difficulty?
I will argue, my lord, he will only have to hear. He has already done his part.
Well, except tomorrow, any other day, my lord.
No, ठीक है, notary clear.
So I have also some other fixed.
On 9 also I can do it.
9
Friday, my lord. No issue, my lord. I'll take half an hour at the most. I'll come
Friday?
prepared with everything then, my lord.
Friday. Okay, on Friday.
Ako ki all.
Friday difficult, yes.
Friday?
8,
Because all courts, my lord, we will have to, my lord, so today also, my lord, this is the difficulty.
No, Friday is okay for you.
Next week, my lord, immediately after.
Next week, this court will be sitting at Kohima for 2 weeks. So in the first week of
I
February.
have to reply only on the legal aspect, my lord.
First week of February.
Only not 5, 6, no? Third but second. Second lolo.
Second.
2nd February.
2nd February. Okay. As agreed by learned advocates of both the parties, rest shall list the matter on 2nd of February. And in the meantime, Mr. Kamar, learned counsel for the petitioner, shall furnish the list of
Yes.
petition relied upon by him to Mr. Borthakur, learned additional people.
Much obliged, my lord. I'm sorry, my lord.
No problem.
We should come prepared. I thought, actually, last time we give one list of books, my lord, we took it back probably. Because last time your lordship somehow did not see it. I remember it. Earlier date. So in that date, actually, we given that election matter one judgment. So that after reading during this vacation, my lord, came to know that this is not applicable in our case.
Okay.
So I withdrew that, my lord. Much obliged.